Well, good morning, everyone. I'm Nicole Cook. I'm one of the legal specialists with ALEI. Can everybody hear me okay? You can hear me? Okay, great. Well, we are very excited to be kicking off things with a deep dive into Maryland aquaculture. As our panelists will remind us, aquaculture is agriculture. And of course, in Maryland, not only is aquaculture big business, it's also culture and tradition. We are very fortunate to have with us this morning 3 panelists, each with a wealth of experience, knowledge, and expertise in Maryland's oyster industry. They're going to give us an overview of the growth of Maryland's aquaculture industry, and then they're going to focus on 2 recent particular legal conflicts pertaining to aquaculture leases. That is the prohibition against leasing bottom with submerged aquatic vegetation, and conflicts that arise when a landowner leases land for waterfowl hunting that is also leased for aquaculture. I'm going to very briefly introduce our panelists. You can see their full bios in our pamphlet. And then I'm going to give them the floor to share their perspectives and insights on these issues, as well as their ongoing or maybe even new concerns regarding these issues and the state's oyster industry. And then after their presentations, that's when we're going to open the floor up to your questions. So to my immediate left is Don Webster. He's the regional specialist with the University of Maryland Extension. Don joined the University of Maryland in 1974 to develop extension education programs in marine science, and that led to his extensive work developing the commercial aquaculture industry in Maryland. Next to Don is Carl Rocher. He's the Aquaculture Division Manager for Maryland's Department of Natural Resources. That's the division that's responsible for issuing aquaculture leases and permits, also for managing the development and operation of the industry, and for enforcing industry compliance with state and federal regulatory programs. Carl has worked with Maryland's aquaculture industry since 1996. And then next to Carl, we have J.D. Blackwell, who is the owner and operator of 30 Degrees North Oysters, and also the current vice chair of Maryland's Aquaculture Coordinating Council. J.D. also serves on the Tidal Fisheries Advisory Commission, the Oyster Advisory Commission, the Southern Maryland Aquaculture Development Commission, and the Potomac River Fisheries Strategic Oyster Advisory Panel. He does a lot of work to promote the industry in Maryland. And with that, I'm going to let you guys take it away. Does anyone need to come up, or you want to stay seated?
I probably won't. I can't stay seated. I'm sorry, Nicole. You were forewarned. Thank you very much. One of my guys I knew years ago, Max Chambers, opened one of the Farm Bureau meetings in Ocean City one year by saying, "I'm a farmer too, but my farm's underwater." And those are the folks that I've worked with for a long time. Welcome, everybody. Thank you, Nicole, and thank you to AELI. It's been one of the great programs of the College of Ag and Natural Resources. We really, really do appreciate it. Quick overview. This is the Maryland oyster industry from 1840 until 2000. If you look at I've broken them into 3 eras. Era 1 was back from about 1840 to 1930. Basically, is a virgin stock over harvest. In the mid-1800s, the toad oyster dredge is imported from New England, where the growers had largely wiped out their grounds. It's introduced to Maryland about the time when we have canning technology, early refrigeration, and expansion of the railroads westward, which opened up vast new markets for our product and lead to a gold rush in oysters down here. The dredges tear down the 3-dimensional reefs that existed at that time. There's a great deal of controversy between them and Congress, leads to the oyster wars of the Chesapeake. And scientists in the late 1800s are warning against the overharvest of the resource. It peaks in 1885 at 15 million bushels. Thereafter drops down rather precipitously. Era 2 is from about 1930 to the mid-1980s. Well, the harvest stays fairly regular, about 2.5 to 3 million bushels per year. There's both aquaculture and wild harvest. In the 1960s, we have 2 diseases, MSX, which is brought in from organisms in the Pacific Northwest, Yarmo, which has been known in the bay since the 1940s. They get up into the Maryland area, cause about 1 million bushel decline. The state institutes a repletion program and activities to manage and try to bring the resource back up. But in doing so, and against the advice of many scientists, they move oysters from high disease areas to areas where it had not previously been known. In the mid-1980s, we have a couple of years with very low rainfall, drought conditions. The salt wedge moves farther up the bay. We have 85-90% mortality, from which we've been trying to return for the past 30 years. So we're about 5% of the harvest now than we were back in year number 2. Maryland was one of the first 3 states in the United States to actually institute leasing laws. With Rhode Island and New Jersey, we had the 1-acre law in 1830 that allowed anybody to take an acre of ground, basically to bed oysters or get natural seed production on them. Expanded to 5 acres in 1865. After we had that peak and the big drop down, we had scientists that are urging aquaculture within the state. In 1906, the Hammond Oyster Law is passed, and that creates the Shellfish Commission, as well as the first modern leasing program. It also delineates the natural oyster bars in the bay to be retained for the public trust for all time. Charles Yates, the biologist who does that, is truly convinced that within a few years we'll have 100,000 acres of natural oyster bars and 200 to 300,000 acres of lease. It was not to occur. Virginia really embraced the leasing program. Theirs started around 1880, 85. The Hammond Law was not well received with watermen in the state of Maryland, and they set out to try to put limits on them. By 1914, the Shepherd's Bill was passed. This allows any waterman to protest the lease by walking into a local court and swearing that he had made at least 1 day's work on that ground in the past 5 years. No evidence, no data required. The judge would then rule on it, declare it invalid. The lease would be placed in the charts of natural oyster bars. There were thousands of acres that were under application time that were just withdrawn because people knew they weren't going to get leases. Over the past 100 years, we had many other boards and task forces that tried to change that, and that did occur a few years ago. Carl?
Great. Thank you, Don. So as Don pointed out, there was quite a bit of activity pre-1980 in leasing, and then the disease epizootics came in, not a lot of activity after that. Leasing program was basically stagnant. A lot of leases in the state that it existed, but not much activity. The state had been watching the development in Virginia, and they were proliferating, a lot of leases, a lot of production on their grounds. Mainly clams is how it started in Virginia and started to transition into oysters. And the state of Maryland couldn't sit back and watch this happen any longer, so things started moving. And even by state government standards, they moved rather quickly. And about 2008, after about 5 years of planning and strategizing, then Governor O'Malley requested a plan of action on his desk in 30 days. And the state agencies got together and put that plan on his desk and basically outlined the need and the reason to change how things were occurring in Maryland and the need to actually revise our leasing laws. So in 1 year, new leasing laws were proposed, and that was in 2009 during the General Assembly session. And we were all very surprised when the new leasing law package was passed unanimously in the House and the Senate in the General Assembly. So bipartisan support across the board, and then things started moving. So new leasing laws passed in 2009. Then in 2010, a regulatory package was developed under that authority, and the Department of Natural Resources opened the new leasing program in September of that year and started accepting applications. So the lease law provisions, the changes that were made, basically we moved from a lot of the specifics related to leasing being in law. We moved those specifics into regulations to provide for more administrative flexibility. And there were a lot of prohibitions, a lot of impediments to leasing that were changed. There were county prohibitions. In the state of Maryland, there were moratoriums in specific counties where leasing couldn't occur, and then other counties they could occur. It was a mess, and the new lease laws changed all that. So we deleted those prohibitions, removed any acreage limitations, so a lease applicant could apply for 5 acres or could apply for 100 acres. And we wanted to move in that direction because literally the restrictions should be based on the site, not based on a prohibition in law in terms of how much acreage you could lease. Also allowed corporations to obtain leases and non-residents, which was not allowed prior to the lease law change. And then finally, we included an active use provision in the laws, which was very important. Prior to these new lease laws, folks could obtain leases. They could sit on those leases, tie up thousands of acres and not use them and or not produce any oysters, and that area could not be leased by other individuals that did want to make it productive. In 2009, we added this active use provision that helped require that leases were being used, and those provisions require leaseholders to use 20% of their acreage per year and plant at a density of 200,000 oyster seed per acre. In addition to keeping that ground active, the active use provisions also provided for a way to prevent what we call vanity leases from occurring, where an individual would lease up an area just to tie up that area so no one else could get a lease out in front of their properties or for other reasons. So the active use provisions help us with that. So in response to the new leasing program being implemented, we took a long, hard look at regulatory oversight within the state of Maryland and recognized that there were multiple agencies involved with permitting, issuing permits, licenses, and leases. And rather quickly, the General Assembly recognized that this is not going to work. We need to consolidate this under one state agency and provide like a one-stop shop for permitting. So in 2011, the General Assembly consolidated all that authority into DNR. A couple of other things happened. Myself, the aquaculture coordinator position was moved from MDA over to DNR, and the DNR also obtained the administrative responsibilities for oversight of the Aquaculture Review Board and the Aquaculture Coordinating Council, who are two groups in the state of Maryland that oversee aquaculture permitting and policy development. Also, another big change in 2011 was that the General Assembly moved to allow leasing in oyster sanctuaries, which were created in 2009 in addition to the new leasing laws. And when they were created, aquaculture was omitted from those areas, but we recognized pretty quickly that aquaculture provides a benefit to those sanctuary areas by increasing oyster populations in those areas, and there was a value for leaseholders for locating their leases in sanctuaries. These areas are patrolled, and there's less of a problem with theft in the sanctuaries on these lease areas. So in response to some of the state's initiatives and the work that was done, the industry has responded very well, and these graphs illustrate that since about 2012, a year after the new leasing program was implemented, harvest has increased every year since then, and last year in 2017, our harvest total from shellfish leases was about 75,000 bushels. So it didn't increase sharply, but it has increased steadily over time, which is exactly what we were hoping to see. So if you look at the numbers today, we've got two different types of leases in the state of Maryland. Submerged land leases, which are traditional leasing activities where you plant oyster shell or clam shell on the bottom and then oyster seed on top of that. Submerged land leases account for the majority of our leases. Currently, about 80% of the leases are submerged land leases, and we've currently got 339 of those leases throughout the state, and they cover about 6,400 acres. Water column leases are leases where you actually containerize the oysters or the shellfish in cages on bottom or floats on the surface. That's a relatively new technology, and there's been strong interest recently in that, but we've only got about 82 leases in total, and they cover about 421 acres. So if you look at the leading counties, traditionally there was a history of shellfish aquaculture production and wild harvest in Dorchester and St. Mary's County, and that's where you see the real strong growth in aquaculture leasing.
If we were Virginia, by contrast, has over 100,000 acres leased. If we could do that here in Maryland, it would be like adding a new agricultural county, but underwater. One of the things we did was to put together an oyster team with all of the state agencies, our friends from Marbidco, I see Steve McHenry here, as well as NGOs, the Oyster Recovery Partnership. We work very strongly with the Bay Foundation and the Coastal Conservation Association of Maryland. Some of the support programs that were put in place, there's a low-interest financing program Marbidco operates, actually has some loan forgiveness to it. NRCS has bottom habitat enhancement figured into their environmental quality improvement grants. Farm Service Agency has low-interest loans for equipment. As Carl noted, we've streamlined permits and regulations. Promotion and marketing has moved from DNR back to MDA. That's sort of been a bouncing ball over the years. University of Maryland Extension was given funds both from NOAA and recently the Radcliffe Foundation to do education and training. We do about 25 programs a year in the state in production systems, business management, seafood technology. One of which is a remote setting training program in order to produce spat on shell or seed for planting for bottom leases. We have 38 systems. It's actually a technique that was brought back from the Pacific Northwest by my colleague Don Merritt back in the early 1980s, where a hatchery produces idle larvae, sends it to a grower, he puts it in a tank with containerized culture material, the oysters set on that, and you plant your grounds. We currently have 38 systems around the state of Maryland that include tanks, pumps, blowers, the plumbing. The grower has to provide the culch and the labor for it. We give them the free larvae from the University of Maryland Horn Point Hatchery. The idea is they work with us for a couple of years, learn the skills, build their own systems, and several of them have gone into this on a very big time. Some of the other things ORP provides to them is lease mapping by side-scan sonar, so you can actually have a better idea of how to work your lease, as well as free dermo disease testing annually. This is what the systems look like. They're either 8 or 12-foot circular tanks. They located in about 8 locations around the bay right now. You fill them with containerized aged oyster shell. My colleague Don Merritt at the statewide workshop that we run at Horn Point every year. You introduce larvae into them. They set for a couple of days, flow water past them, grow them up, and then plant them out on your leases. Since we started that program, we began initially with about 12 growers and 38 sets and doing 33 million seed. The last few years, we've maxed out the systems, 45, 46 growers, 212 sets, and they're doing 250 to 300 million seed oysters to plant leases now. So that's been, it's been very, very popular and done very well.
Absolutely. So in addition to some of the programs that were created, as you can imagine, with the new leasing program and some of the initiatives the state has undertaken, there was a lot of problems along the way that needed to be addressed. So just touching on some of those, we removed some of the restrictions, as I stated, in the old leasing laws with our new laws. And the reason we did that, we were trying to create an infrastructure of support for the development of the industry and to attract private investment and, provide that opportunity, get private investment, get folks involved in leasing, and things have taken off since then. As I stated, we created a single point agency with these support programs that Don has touched on for our applicants. They've been very successful. One of the other issues that we tackled early on was reducing the requirement or eliminating the requirement for leaseholders to adhere to wild-caught restrictions, and one of those was size restrictions. So wild-caught oysters have to be a minimum of 3 inches in size before you can harvest them. There's a call law on the books, so we took action and passed law and/or regulations to make it clear that shellfish aquaculture producers, they own the product, they can harvest it at a size that works for them. And so the legal size limits were lowered with a minimum of 2 inches in size for shellfish aquaculture producers. As I stated, we also revised the active use provisions, and our permit process is streamlined and much more user-friendly. We also took some action early on, recognizing that leaseholders needed a supply of oyster seed or young oysters to plant on their leases, and a number of growers wanted to establish shellfish nurseries where they could grow oyster seed that would supply, or they could use that seed to plant on their leases, and there were problems with permitting for those shellfish nurseries. So we took some action to try and streamline that, and then also provide exemptions from water appropriations and discharge permit requirements that existed with MDE for those operations. Idea being, these are flow-through operations where nothing is added to the water, and in some cases, most cases, in fact, the water is cleaner when it comes out the other side of a nursery operation than when it went in. So it didn't make sense for these folks to have to go through the red tape of getting appropriations and discharge permits given that situation. So we got exemptions for that. And then also at DNR, working through our processes, which include our public process and the ability, and I'll come back to this in a future slide, the ability for an individual to protest the issuance of a lease. As you can imagine, we've received a number of protests, and our Office of the Attorney General has been working on those, and through the years has gained some important legal precedents in terms of what is a valid protest and what is not, and that's helped us considerably in moving through some of these. So kind of as we stated, some of the outcomes of that, strong industry growth, a number of companies have gotten leases since 2010, and they've already come back and requested additional acreage because they've been very successful both in growing the oysters and in their markets. So we've got a lot of our existing companies that are expanding. Waterman, one of the targets when we were trying to expand and create the opportunity for shellfish aquaculture growth, one of the targets was Waterman, to try and transition them from relying on an unsteady wild oyster harvest, try and transition them into leasing, and that's been very successful. About 50% of our leases are held by people that hold title fish licenses, Waterman, so that's actually worked out well. And then we've seen, as I stated, a continual filing of applications. We've got about 130 or so applications in process right now. And those include new applications and existing operators that have applied for additional acreage. So, as usual, success doesn't come without challenges. And one of the challenges that Nicole had stated and we've been working on recently is the issue of SAV encroaching upon existing leases. Our current laws prohibit the issuance of a lease in an area where SAV, or submerged aquatic vegetation, has been identified as present on the area within one of the last 5 years. We do a 5-year composite, but that doesn't help us with the existing leases. So once a lease is issued, when SAV encroaches on that, we're required currently, under the way the law is written, to restrict that individual from working within the area of their lease that has SAV on it. Through some discussions, we felt like this issue needed to be looked at. We brought it to the attention of the Aquaculture Coordinating Council, who decided to establish a work group to look into the current situation and then present some findings and back to the council, and then the council presented those back to DNR. Some of the things that were discussed in the work group meetings and were part of the findings was that, which folks pretty much knew, and it was validated through the work group, that SAV and shellfish leases both have positive environmental benefits. So why would you restrict one from the other? Just because there was encroachment shouldn't mean that an individual couldn't continue to plant those oysters. So that was an issue we looked at. And then also one of the types of activities that I stated earlier, the water column leases, those activities don't cover 100% of the bottom. So even if SAV does encroach on the lease, you're not covering 100% of that SAV. There's still sunlight penetration. The SAV can grow around these cages. So we need to take a long, hard look at restricting those in the future. The findings also moved down the path of making specific recommendations back to the council, which were eventually carried out to DNR, and those were a recommendation to modify the existing laws to allow more flexibility to the department in examining or evaluating each individual case, so some changes could be made in situations where you weren't actually damaging SAV and looking to allow those aquaculture activities to continue. And we're currently working on a legislative package for 2019.
Theft has been a problem with shellfish aquaculture for decades. One of the first oyster conferences I ran in 1979, it was listed as the #2 concern. If you take out anything away from here, it is not poaching, it is theft, either of private or public property. It's been a work group that's been looking at this year. We're looking at things like development of technology for monitoring, protection, better enforcement projection in areas of known problems, a better coordination of court cases, and stricter punishment for violators. When I was first on the job, I had some good waterman friends down Tillman Island, and one of them got telling me about the illegal hand scraping used to go on down there, and he looked at me and finally said, the only way they broke it up was when they started taking boats and gear. They used to impound the vessels when they got them. They made it too expensive to continue. And that's the lesson we have to take away here. And we're going to be working on this over the next year.
So moving on, another one of the issues that we're currently working on is our lease protest process. So currently, An application comes into the Department of Natural Resources. As I stated, we've got about 130 or so in process now. We've been continuing to receive those. The process for review includes agency review within DNR. We take those applications both through the department, through other state agencies, and we also coordinate with the Army Corps of Engineers, and there's a federal review associated with those applications and/or approvals. Once an application moves through both of those processes and we get to the point where we can actually move forward with issuing a lease, the state issues a lease, and then the Army Corps of Engineers issues a Department of Army permit. So you have to get both of those authorizations before you can proceed with leasing activities. Part of our process at the state of Maryland includes public notice and advertisement of the lease. We advertise the lease application once a week for 2 consecutive weeks in a local newspaper in the county where the project is proposed. And then that's followed by a 30-day comment period that allows any member of the public to submit comments to the department with respect to those applications. And in that process, or in that public process, any member of the public can request a public information meeting about the project. And we set up like a poster session or an open house in the county where the project is proposed if a public information meeting is requested to try and provide interested parties with additional information on the project. In addition to that, an individual or a member of the public that feels they have a specific right, duty, or privilege that differs from that of the general public can also file a petition of protest with the department against the issuance of the lease. And currently, and this is where the problem arises with the protests. Currently, there are no specific requirements in terms of or criteria for standing. So an individual can file a protest, can claim that the lease is aesthetically unpleasing, or they just don't want it out in front of their house, and we have to take it through the entire process, basically through agency review, and then move it to the Office of Administrative Hearings for adjudication. Very long, costly process. And we feel like, and we're currently looking at that protest process to try and streamline it somewhat and actually set some boundaries and identify for members of the public what does constitute standing in these protests to try and avoid some of the wasted time that we've seen in processing these applications.
A lot of those, as Carl mentioned, had perceived user conflicts, shoreline property owners. Basically, don't like to see water column leases, which do have more of a presence out in front of them. One of the interesting things we've seen with surface floats, and Mr. Blackwell runs one of these operations, is that one of the biggest problems we have in the bay is erosion. And the surface float culture actually stops wave action, and in several cases that we've seen actually helps to prevent erosion on the shoreline. So I'd like to see some research to see how we can control that and bring that together. Commercial harvesters are another group that has protested, as they have for the past 150 years. We've had a lot of difficulties with this. We've tried to delineate clam grounds so that you're not taking something that a waterman finds extremely valuable. But in a lot of these cases, it's very much based on opinion. I have a trot line lay there. Well, I use that for a couple of months in the summertime. But here's somebody who's investing money that has environmental and employment benefits to the state. There is a process going on with the department right now to try to mitigate that somewhat.
Okay, so the last issue that we wanted to discuss with respect to conflicts that we see out here now is the issue associated with waterfowl hunting blinds and shellfish aquaculture leases. So there's a long-standing history with both, probably more of a history with the waterfowl hunting blind sites. And as you can imagine, as you see more aquaculture development, more leases are issued, the conflicts between these two activities is going to increase. Traditionally, these two activities have existed without conflict, but recently we've seen some issues arise that need attention. So the statutory authority is pretty clear, both for shellfish aquaculture, issuing shellfish aquaculture leases and issuing waterfowl blind sites. And that is, there's clear statements in the law that basically if the applications meet the criteria established in the subtitle, the department moves forward and issues the lease. So there's no requirement for consideration when we're reviewing for our aquaculture lease applications, we're reviewing for issuance of the lease. There's no requirement to take to take waterfowl, the existence of waterfowl hunting blind sites into consideration. And conversely, there's no requirement under the wildlife and heritage laws to take a shellfish aquaculture lease into consideration when issuing a waterfowl hunting blind site. So this has created somewhat of a conflict recently. A lot of the folks that have been involved in this have worked it out. Basically, we facilitate communication between the parties, and they will talk to each other and make determination on what days of the week they'll be hunting, what hours they'll be out there, and the leaseholder will basically make, in some cases, a handshake agreement, or in others we've seen written agreements that they won't be out there during those days and times. Also, we have in law, there's some protections that exist currently. A shellfish leaseholder can't work their lease within 500 yards of an occupied blind site. So basically, you're out in a blind, you're using it for waterfowl hunting. Common sense, you wouldn't want to be there anyway if you were a leaseholder. Folks are out there gunning birds, but they can't be within 500 yards, so there's some protections out there currently. What we have seen in just a few cases are, once we issue a shellfish aquaculture lease, we've seen individuals apply for blind sites either in different areas closer to that lease or within the boundaries of the lease in an effort to try and prevent that individual from working their lease. So these are some of the things that are developing that we're going to continue to work on. And similar to what we've done with SAV, the council is taking this under advisement and looked at the potential for establishing work groups and or working with the department's Office of the Attorney General to see what can be done either in law or through policy to try and address some of these issues that are occurring.
The challenges to the lease program, Scott talked about the leasing and sanctuary zones. When this was originally done, it made good sense, because what are you trying to get in the sanctuary? More oysters. Who cares who puts them there, the public or the private? The original agreement was it would be limited to 10% of that area, and there would be 150-foot clearance from Yates bars. The handshake agreement was if we got to 10% and everything was working well, we'd probably up that cap, so we're hoping to see that occur. There was a bill in the legislature last year, one of our politicians, Eastern Shore, put in, that would have made 1,000-foot clearance around Yates bars. And the legislator who put it in didn't even know what a Yates bar was when he submitted it. So there's been a lot of education need to be done in this. There is a current study group DNR has to try to isolate some of these issues and try to bring them to resolution. The redefinition of leasable areas. We had another Eastern Shore senator last year who submitted a bill that would have made any bottom that had 1 oyster per square meter automatically placed in public shellfish fishery area, or what used to be natural oyster bars. One of the problems with that is oysters are proximate spawners. They're made to aggregate. That's a reason why females have 10 to 40 million eggs they expel. They have to be a lot of oysters in one area in order to get good reproduction. Some of the work that's been done, 1 oyster per square meter, you have less than 0.5% probability of fertilization. The feds assume 50 animals to be a restored area, and that's still fairly low. What the aquaculture growers are doing is far more than that, in the 200 to 300 or 400,000 animals per acre. So this is some of the things that we need to take care of. I have no doubt the bill will be submitted again this year. What has occurred? This is our industry. These are the great people who have been in there. JD, who you're going to hear from. Scotty Robinson was coming out of a waterman family in Hooper's Island. His dad told him, Scotty, there's no future for you on the water. Go find something else to do. He went into auto body. When his dad got involved in one of the oyster companies, he said, Scott, come back and work with me for 5 years. We're going to make this work. Several of these, Scott Budden is up in the Chester River. Dick Baldwin has a precision machine shop in Baltimore. He's down in Wolford. He's done oysters for decades. Christian C. Gordon in the coastal bays. Casey Todd, his family's been on the bay for 150 years. They have Tompkins Seafood in Chrisfield. And he's been really, really involved. He could not get a lease when we first started teaching remote setting. It took us a generation to get him back into the business. Bobby Leonard is one of the Talbot County's big grain farmers. He's one of our biggest oyster farmers. He's a crab buyer and has a crab house in Hyattsville. There's some really great people out here in the industry. Pat Hudson and Patrick Hudson, his dad, have True Chesapeake down in St. Mary's County. They also have an oyster bar they started in Baltimore City. They're building 2 more, and they're going into a restaurant. So there's a lot of good people. Eric Wisner was in the logging business. He's got some of the leases down in Wacomico that were traditional back in operation. He now farms 600 acres and doing very well. So with that, one of our success stories, J.D. Blackwell over here. These are some of the shots of J.D.'s leases. As 38 degrees north, as Nicole said. J.D.'s going to cover some of the specific issues that he's had with his leases.
Thank you. Good morning. So there's a wide range of subjects here, and if we don't get to them, I want everybody in the room to feel free to call me or email me outside of the conference, and I'll happily chat about it. Also, please excuse me. I seem to have started to come down with a cold last night, so please excuse my voice. Anyway, what you see here, so here's a nursery system where I'm growing small animals to get planted. Here's a floating cage system that I have. Here's bottom cages. So you're going to hear a lot of words. I assume that most of you aren't familiar, but first thing I want to help you understand is there's really sort of there's one big divide. There's some people that have what's called a submerged land lease. Essentially, they try to recreate an oyster bar on the seafloor. It's the public fishery is basically you go out and harvest oysters off of an oyster bar on the seafloor. They're basically, I don't want to say in the mud because it's got to be hard, but it's literally the oysters are growing at the seafloor on the bottom. Think of it as a reef. Secondly, there is a section of aquaculture that reproduces that. We call those submerged land leases. On the other side, there is operators like myself who put oysters that are already single oysters, they're not clumps, in a cage. And so you might consider it containerized gear. You might consider it containerized farming. Generally, it's called water column. So I do that here in a cage that sits on the bottom like this, or in a cage that floats on the surface like this. So with respect to SAV that came up earlier, I've got a couple different pictures here of leases. So, oops, let's go back. So this here happens to be a lease, and this here is a drawing that shows VIMS, a university in Virginia, establishes where the SAVs are at for the watershed. So here's an example where here's from a state permitting website, shows here's a lease, and there's just a little bit of SAV right here on this very edge. So a person would think it'd be fine to go out and put containerized gear on it. However, the next set of data, meaning the data from 17 that will show up, is being looked at now in 18, that will show up on the state website for 2019. I keep pushing the wrong button, I apologize. Shows SAV now is here and here. So a person would have thought it was completely fine to go out and invest, in this case, this would be $1 million plus worth of gear in a site that would then, 12 months later, become unusable in large part. Now, there's an argument that could be made. You're only currently DNR, and DNR is great about this subject, and I mean that sincerely. They only tell you you can't use it during the time of the year where there might be SAV. Unfortunately, as a practical matter, if you can't work your lease all summer, not too much you're going to do with it all winter. You actually spend all your summer putting the oysters in, they get bigger, you put in more gear, it expands, and essentially you set up your crop to go into winter. So if you're only allowed to work it in the winter, not much is practically going to happen. So this is an example of how the SAV law unintendedly is shutting us down. So that's one example. This is another example of leases I have and I'm actively using. And I did that wrong again. So here's lease, here's lease. This is a big open area, hard bottom. And the hard bottom in the big open area means there's a lot of energy. There's a lot of wave action in there that tears up the bottom. It's constantly swirling around the sandy bottom. So SAV isn't likely to get started. However, this is a different map, and unfortunately I can't overlay the two. But if you see back here near the edge, here's new SAV all growing. It's not much of a stretch to connect the dots between activity out there in the front and the SAV that's now getting to take hold behind it. So that's an example of how the actual aquaculture operator is likely to be encouraging SAV growth. So by being successful as an operator, you stop yourself. So success was not rewarded in that case, and I think that's going to be a growing trend. Here's another example of a lease that I put together this year, where the bottom visually appeared to have almost no SAV, an occasional, and there's different types of SAV, and those different species, there are different factors to be considered. But in this particular case, this is Widgeon's grass, and there was essentially zero Widgeon's grass out there on May 29th. Now this is a picture taken late in August of the same year, after hundreds of cages have been installed. And you'll see that VIMS believes all this stuff here in between the rows and here is SAV. And it likely is, although visually to me it doesn't appear when I go out there, it doesn't appear to have that much sort of substance to it. So here's an example where go out, look at it. Visually there's no SAV, put gear in, SAV comes, and it creates a problem, essentially shutting this down, requiring for all this to be either not used or taken out. So this is me illustrating the point. Also, to a small point that Carl addressed earlier, if you look at this area, and you consider this line, that line's the only thing we're talking about. That's a cage full of oyster. The actual percentage that's being occupied is 1%. Is 5%. So I'm running out of time, not going to get a chance to chat about all the other different issues. But this is me showing you one example how the law is currently, maybe unintentionally, but it's impeding the expansion of this industry. I will say this just real quick. So I'll be 10 seconds, I promise. Here's a lease at application where there was one duck blind. Those leases I just showed you all got issued. And then after the leases got issued, the nearby property owner, this is showing you all the new duck blinds that got permitted after the lease got issued. Sorry to steal that minute from you, but I think that makes the point about duck blinds.
Well, thank you very much. And JD was did want to
Sure.
Actually, we're going to open it up for everybody's questions in just a second, but before we lose you for the day, I wanted to actually talk about the lease protest process. And as a former practitioner, I'd like to know more from Carl and JD in particular. What are some ways that council can help assist smooth the path or make the path smoother in terms of obtaining the leases for those councils that work with industry owners and industry? Because JD, you didn't get enough time to talk about that, but I'm curious about your perspective on that.
Who do you want to start? So, well, let me tell you one very quick story. I had a lease, not one of the ones you've seen here, but I had a lease next to I already had one existing lease. I asked to expand it because it was doing well. It got protested by somebody 2 miles away who was not in visual sight. He happened to be an attorney. He protested it with the basis that he owned land and somehow me 2 miles away was going to affect him. He wouldn't meet at the mediation and any of that process. He took it all the way to the ALJ. He walked into the hearing, and literally the first thing he said is, I withdraw my protest. So he simply used the protest process as a way to stall me for nearly a year. Now, that has impact in real dollars and real parts of a business plan. So I tell you that as a story to say that, as Carl said earlier, the whole thing is completely open-ended in terms of what they have to respond to. So in terms of what you said an attorney might do, the first thing that we fundamentally need is some type of standard. Because at this point, anybody can say anything, and it puts you into this very long and expensive cycle. Now, it may or may not be expensive for the applicant, but it is certainly expensive for DNR. I don't know, obviously it's a question for Carl, but I suspect that half of their time goes into dealing with protests, many of which shouldn't lead anywhere. And so when I say it's expensive in terms of state labor staff, as well as it distracts them from getting to other leases and addressing other issues. So I think that's the first thing that needs attention.
Anything?
Sure. So as JD said, it's absolutely costly, time-consuming, involves a lot of resources with the department, but I don't want you to think that it's not an important part of our process. It absolutely is. However, as I stated in my presentation and coming back to Nicole's question, we definitely need some standards established out there, and I think our collaborators and the groups that we work with, it would be good if we could get them together and actually start looking at what are acceptable standards. Not going to say we're going to get consensus on those, widespread consensus, but to establish some of those acceptable standards that put a boundary on or a border around these concerns and establish standing would help considerably, absolutely.
I mean, one of the positive things, the attorneys general in DNR are some of the most magnificent people I have ever seen. They have fought like pit bulls and I believe have won every one of these over the years and established some very important precedent in state law.
Thank you. I think we can open it up now for questions.
Hi, I understand that there's some discussion of nutrient management, phosphorus remediation, or other things going on that the shellfish industry is involved in. And I was wondering if you could talk a little bit about that.
Yes, ma'am. Nutrient trading payments have become a big issue. The Aquaculture Coordinating Council has dealt with this somewhat. There was an expert panel put together a couple of years ago to look at best management practices for that. I believe that is moving through. It has not yet reached fruition, but what will very likely occur is that those, like Mr. Blackwell doing contained culture, where you can actually put numbers on an inventory and understand what the nutrient cycling is doing, may become eligible for payments in the future.
We have time for one more, Sarah?
If I can respond to that, certainly there's the whole spectrum of possibilities. So I would never want to pretend that this is a 100% statement. But in my experience, I don't see it at all. I see SAV is returning and flourishing around cage gear. Cage gear, containerized gear, water column, however you want to refer to it, I think is having dramatic environmental benefits. Yes, we're cleaning the water, we're filtering the water, making it clearer, and that helps SAV. But we're also, if we're blunt about it, we're fertilizing the bottom. So we're making the seafloor more fertile. And there's a lot of chemistry there, and there's a lot of conversations that can be had. But the bottom line is we are providing fertilizer for it. And we're having an impact on a very small footprint. So I believe that we reduce wave energy in some situations, not all, but we reduce wave energy that lets it get started. I showed you an example of that. As well as, I think we're fertilizing, as well as there's a whole lot of other subtleties, but one big thing that never gets said, and I'll say it here, is that to some extent we're providing the same service. So even if we displace 5% of the SAV, we're providing that habitat, in many cases better than the SAV, for all those other little critters that want to live and grow and need a place to hang out while they're little and feed and spawn and all that.
Very informative discussion. Thank you. I'm Adel Shir Mohammadi from University of Maryland, College of Ag and Natural Resources. I was wondering what is the impact of the recent extreme weather conditions, waves and stuff on into it. Can you all hear me?
Yes.
Yes.
Okay. So I was wondering what the impact of the recent extreme weather conditions, violent storms and waves and so on, are on the aquaculture oyster farms that you all presented some of the examples. If there is any impact on the motion and so on and so forth.
So I think I'll field that one. So with respect to violent storms, that's pretty normal, so I don't know there's anything different. Yes, that impacts floating gear and can be helping or hurting, and it can in fact help, but it mostly could hurt. But the biggest environmental issue for this year, if that's what you're referring to, is the tremendous amount of fresh water that's in the watershed. It's lowered salinity dramatically. Salinity's off maybe 50, I mean, it's varied, but certainly as of May, we've been down to very low levels, historically low, and that's had a big impact. In my particular case, and in many people that I know, the biggest impact is that it has slowed growth rate. Animals that should have been ready in June 1st to go to market are just getting ready now. So there's been a statewide, and I think it's true statewide in general, there's exceptions of course, but in general it has dramatically slowed both the public and the private growth rates. And many people feel there's been mortality as well. That's a harder thing to quantify because there's some natural mortality. That's just a part of what we do. So I have no doubt there's been an increase in mortality. How significant that is, it's hard to quantify honestly. But what is not at all uncertain is that most of this growth season's been lost.
We could keep you here all day, and there are multiple issues that we didn't get to address today, but thank you everyone, and please join me in thanking our panelists. Thank you so much.
Thank you.